Burke. I'm the clerk of the Circuit Court and Comptroller for Pinellas County, which is the beautiful St. Pete Clearwater area. It is my pleasure to call this meeting of the Guardianship Improvement Task Force to order. We appreciate everyone's attendance, and we're going to get started by a roll call. I'm going to ask Kimberly if you would please give a roll call of the members of the task force.
And it is on YouTube.
Down at the bottom.
Yes, sir. Just one moment. As we had with the last one, there's just my computer is frozen for the moment.
And that's fine. Fine. I'll go ahead and get started with the task force roll call then. Crystal Kinzel.
Here. Good afternoon.
Good afternoon, Crystal. JD Peacock.
We got it taken care of.
I'm present. Thank you.
Thank you. Senator Jennifer Bradley.
Yes.
I'm going to send it to another.
Representative
Yep.
Colleen Burton.
Here.
I will do that.
Thank you, and I hope you're doing well.
Thank you, Ken.
Magistrate Shaud Canagan. Retired Judge Jose Rodriguez. Judge Michelle Morley. Sancha Brennan Wynot.
Present, Sancha Brennan.
Thank you. Michael Lincoln McCrae. Anthony Palmineri.
I am here.
Gina Rosie Scheiman.
Present.
Tamara Cribben. Viviana Vanella Lopez.
Present.
Hillary Hogue.
Present.
Dennis Moore. Zane Smith.
Present.
Mike Donovan.
I'm here. I'll have my video on in a couple of minutes.
Thank you, Mike. Shannon Mackenzie Miller.
I'm present.
Bob Estelos.
Present.
Richard Prodon. Does he have a representative from Elder Affairs? Karen Morello.
Present. Hello.
Thank you. Thank you, Karen. Is there anyone's name I called who didn't have a chance to respond and would like to respond now?
Tamara Cribben.
And this is Sean Cadigan. I'm sorry, I just arrived a little late.
No, thank you. We understand you're busy. Anyone else who didn't respond to the roll? Thank you. That's good attendance for today. Appreciate that. Before we get on with the business of today, I do want to acknowledge something. A letter was received from the Florida State Guardianship Association. The letter recommended appointment of an authoritative guardianship law study commission. Allow me to thank Gina for her association's letter. Clearly, her organization's recommendation should be considered by the Guardianship Improvement Task Force, just as we intend to consider other proposals for possible inclusion with our final report. The Florida State Guardianship Association's letter also raised a concern about the timeline under which this task force is operating. We have recognized from the start that the work of this guardianship task force will be conducted within a tight time frame that is a challenge that we have acknowledged and embraced. There is no one method of achieving improvement to any public policy. In the case of guardianships, there have been past groups and commissions that have met over a long period of time. Reports have been issued, and yet it is widely acknowledged that Florida's guardianship program is not a national model. In fact, most would agree it has serious flaws. While I have strong confidence in the abilities of this task force, no reasonable person can believe we will solve all the issues and come up with all the remedies to guardianships in the state of Florida. This task force can, however, make relevant recommendations to create a pathway for further improvements to guardianships in Florida. Our report can serve as a catalyst for further action. We certainly have a wide range of views and perspectives on this task force, as is evidenced by the variety of entities represented through our membership. I know of no other task force that has existed in our state that has examined this issue that has such a wide range of views and perspectives. Because the expertise is assembled, we have the ability to make serious legislative recommendations to move the needle in a positive direction. Thank you again to Gina for the recommendation contained within her letter and for offering the perspectives of the Florida State Guardianship Association. One of the items at each of our meetings, which is so important to us and which has been a very vocal part, is the public comment. And to give us instruction on how public comment will work today, I'm going to call on Kimberly. Kimberly, are you available and back online to be able to give us how public comment will work? Okay, I guess Kimberly's computer.
Ken, this is Sean. I'm sorry, she had to restart her computer, so just give her a second, but she should be on here shortly. But real quick, I just wanted to let you know that. Kim,
Okay.
are you there?
Yes, I am here. Let's see. Does everyone see the PowerPoint slide?
Yes, we do.
Yes.
Yes.
Wonderful. Okay. Sorry for that. I appreciate you very much for being patient with me as we get through this. Ken, thank you for appointing us for public comment. For today's virtual meeting and going forward, we're going to reserve the final 30 minutes of each meeting to take public comment. Similar to last week's session, or 2 weeks ago, excuse me, we have a process today for the submission of written and verbal comment. For those who would like to submit comments in writing, please visit the contact page of the Guardianship Improvement Task Force website, and the link is included on this slide for you. For those who would like to submit verbal comments today, in the description section of today's YouTube meeting, you'll find a link to join the Webex application directly. If you're unfamiliar with Webex or have not used it in a while, we urge you to allow your computer the opportunity to download and update any necessary software during the course of today's meeting so that you are able to present your comments to the task force a little later on. In the description, you will also find a way to connect via phone only. If you are unable to do so or do not care to connect directly to the Webex application. Similar to 2 weeks ago's meeting, and based on the number of individuals wishing to comment today, we're going to start by allotting 3 minutes per speaker. Note that I will be keeping time and will alert you verbally when you have 30 seconds left, 10 seconds left, and when your time is up. We apologize in advance for any interruptions, but we believe this is the best way to handle public comment during a virtual meeting. Our process will be to take those who have joined via Webex first. Please use the raise your hand feature located in the bottom right corner of your screen, and we will take you in the order that your hands are raised. And then we will take comment from our call-in users. At that time, I will unmute the phone lines and ask one of you to speak at a time. As noted on the screen for the PowerPoint, if you are on YouTube and choose to join via Webex, we do ask that you disconnect from YouTube when you join Webex, just because it has created audio issues in the last meeting, so we wanted to correct that moving forward. So Ken, does that handle it for you? Do you feel that anything else needs to be mentioned for public comment?
Thank you, Kimberly. We appreciate it. Any task force members have a question concerning public comment? Seeing none, I would like to point out that the meeting notes for the first two meetings, or not the first two meetings, our in-person meeting, which was held on July 28th, have been sent to you. I want to thank a person I work with, Karen Lamb. She was the note taker at our meetings. 31 pages of notes are there. If anyone has a question as far as comments on the notes from the task force where they feel something is maybe not as accurate as they think it should be, or if they have any comments concerning what's contained in the notes, please go ahead and write either me or Kimberly, and we will certainly respond. But we thank you, Karen Lamb, for the wonderful note taking, and this provides a great record of our proceedings, 31 pages of it. We also had sent out the August 5th, which was a 2-hour meeting. Again, very thorough notes taken by Karen Lamb. If any of you have comments or questions on those notes as far as their accuracy, please please let us know, and we certainly will address that. We do have the chat feature available to people. I would ask, obviously, I can't restrict what's put in the chat feature. I would just ask for people to use their good comment, good judgment, and respect for each other. The rules we learned in kindergarten of being nice to each other for the chat feature. So I would appreciate that. And especially there may be sensitive information about certain guardianships. I would just be careful in what you say. Maybe do you need to name a name and that type of thing? Or can you just tell your point of what you would like addressed in the chat feature? So you're certainly welcome to be heard. I don't want to hamper any people's comment, but I just ask, be as respectful as possible. Thank you so much. And I see a comment disagree with me on the rules of kindergarten as far as human rights, and I respect that. So thank you. Has any other task force member or representative joined our call since I called roll and were not identified?
Hi, good afternoon. This is Shantae Jones joining for Secretary Pruden.
Wonderful. It's nice to have you again with us, Shantae. Thank you so much.
You.
Anyone else?
Sorry, I was out of the car probably when you called roll. Michael Lincoln, I Decide Florida, supported decision making.
Yes, thank you. Appreciate that. Anyone else? Very good. Today is a program I've been looking forward to for a while, and that's to learn about what other states are doing. And as you all know, guardianship throughout this country has become a major topic. Britney Spears certainly has elevated the topic, but that shouldn't be the reason why. There's lots of we'll take press on the topic because it does help to elevate the topic in everyone's mind. But throughout the past few years, legislators have been dealing with guardianship reform in many states across the country. And Tom Hall has been kind enough to put together a presentation on this topic. I'm not sure how many of you know Tom's background. Tom is a very distinguished person. He's been a lawyer for a long time, grew up in this area in the state of Florida, went to the University of Miami. He was the longtime clerk of the Supreme Court of the state of Florida, a very exalted position, and Tom did it extremely well. He retired from that position, and the Clerks Association was kind enough fortunate enough, I should say, he was kind enough to affiliate with us as a consultant. And he's a very intelligent man, very thorough in his thought, and the person who's going to be writing our report for us to take a look at and to have great, obviously, it's our report, but he's going to put our thoughts into writing. And so I want to thank Tom for his presentation today and what other states are doing. And he has recruited 2 people to assist him in that effort. And I'm also very grateful to them. And they bring a world of expertise. Erica Wood is with the American Bar Association, and she has been part of the association dealing with the Commission on Law and Aging. Actually, she just recently retired from the ABA, but she almost dedicated her entire career to the issues of guardianships from the ABA's angle, and she has some input on to help Tom with what some of the states have been doing. She's been monitoring that. She is an attorney. We also have Sally Hermey, who we heard from a little bit earlier. She's retired with AARP after 23 years. As I mentioned, she's an attorney. She teaches elder law at George Washington University Law School in DC. She's lectured on this topic numerous times. And she's both a resource people. They're not here to present, but they're resource people because they carefully monitor what's been happening in states throughout the country on guardianship reform. So they'll be a great resource for us to look to for answers to questions we may have of what's happening in other states. I also want to acknowledge that Senator Bradley has joined our call. And Senator, so nice to have you as part of this task force and being in this call along with Representative Burton. We certainly appreciate you taking the time to be on the task force on this important issue. So I'm going to turn it over to Tom Hall for his presentation. Tom?
Thank you, Ken. First, greetings from North Dakota. I'm out traveling around the country. I told some people yesterday, later today, I'll be going to South Dakota, and I will have then visited all 50 states plus the District of Columbia, which I'm pretty happy about. But so we're going to get started. I want to go over a couple of housekeeping things on our thing first, and I want to definitely thank Kimberly, who did the real hard work on putting together the PowerPoint presentation that we're going to go through. I would say we're going to go through it pretty quickly. We don't have a lot of time. We definitely want to leave the time for questions at the end and also for public statements. Normally, I like to take questions as we go through a presentation, but today we're going to do it a little differently. I'm going to try to get through all the information as quickly as I can. And then we have Sally and Erica available, and they are far more experts on this than I am. And when we get questions, I most likely will direct the questions to them to help answer them. I think they have more experience in this particular field than I do, and I think I'm glad they're on with us today and can help answer those questions. So with that, let's get started, Kimberly, and we'll go to the first slide. So as Ken said, we want to talk about what successes they've had in other states. And one of the things, when I first got involved in this, I was not that familiar with Florida's guardianship statutes, but I did want to see, and I started reading, and I started seeing a lot of issues that pop up, like a lack of a database, like we've talked about here, other sorts of issues. And so I started looking around to see what people were doing. And almost immediately I discovered what's going to be the source document for this PowerPoint presentation. And that's an ABA report about what was adopted last year in the other states, so 2020. So what we've done is we've taken that report and we've tried to that's a summary of that legislation that was passed last year. What we're going to do in this PowerPoint today is we're going to have a further summary of that. At the end of this, and I'll talk about this in greater detail, both the PowerPoint and the source document, the ABA report, will be put on the website and they will be available. And you can see there are much more detail, and I'll talk about that at the end again. To go over it, we'll give you the link where you can get that information and directly see the PowerPoint or see the source document. So I'll discuss that in greater detail at the end about how you can do that. But at this point, let's move on, Kimberly, to the next slide. So the next slide. There we go. So one of the things that I want to talk about as a sort of background is that, and we'll talk about some of this legislation that's passed in other states, and it's an amendment to the Uniform Guardianship Act. And the act has a really long name, and if you look there on the first line of the actual text, it's an abbreviation for it, but I'm just going to refer to it today as the Uniform Guardianship Act. Florida's one of only 4 states that hasn't adopted it. And the reason that's important, and we have a link to why people think you should adopt it, but the reason that's important is when you look at legislation that's passed, you do have to look and see that they've got the Uniform Act and how that new legislation interacts with the Uniform Act. And so some of the stuff that we're going to talk about, it's hard in many ways to actually relate it to Florida because Florida doesn't have the Uniform Act. So we'll have some discussion about some particular things where that really applies, but I wanted to set that first as a sort of background about where we are and how Florida is a little different from other states in that they don't have the Uniform Act. So next slide. So I'm going to talk again about some of the reform that's been happening. And again, I want to talk to the source document for this whole entire PowerPoint, and that's this report, the 2020 Adult Guardianship Legislation Summary, American Bar Association Commission on Aging, which they put out. It has way more details than we have in this PowerPoint. It has at the very end of it a really great table which summarizes every single act that was passed and what it was about. And again, that's going to be part of that report that we put online. We'll make that available to you at the end of this and after this is over. Next slide. So I'm going to talk about this as opposed to just going state by state. I've broken it down as the source document does into the various types of reforms or legislative changes that have been made. So one of those is to supported decision making. And as I know, all the people who are really familiar with guardianship know, this is really a trend that's occurring across the country. Instead of having just the guardian make the decisions, supported decisions where it's a sort of joint decision so that people can still be, depending on their cognitive abilities, can still be involved in that decisions that have to be made. So there's a whole resource center. We've got a link to that in this PowerPoint about supported decision making and where we stand on that. And that's a real trend, and we'll have some further discussion about that and some of the stuff that states have done as they've gone through. Next slide. And as I said, several states have now statutorily recognized supported decision making as an alternative to guardianship. As I looked and read through some of these statutes, they're all slightly different, which can be expected because every state has different laws and they have to really sort of match their whatever they pass new with what they have in existence so that there's not conflicts created. Supported decision making as a less restrictive option to guardianship, or depending on the particular state, is something that works in tandem with guardianship, so that people have the right to make their own decisions whenever possible. And so I think as we go forward, that's something the task force is going to look into. And again, the source document for this, which we're going to make available to you, has a lot more detail. It will have the specific statutory sites. So if you want to go individually look them up, you can. Next slide. So as I said, we're going to talk about this in particular areas. And the next one we're going to talk about is pre-adjudication issues. In other words, before there's a decision been made about a guardian, there's some issues that states have dealt with recently, and we're going to talk about those now. Next slide. Procedural changes, as you can see, and everybody can read, and eventually you're going to get this full text and you're going to get the full underlying source document. So I'm not going to reread all these things. I'm just going to want to talk about some of the things that here. As you can see, Idaho recently passed a statute that adjusted the time frames to sync guardianship and conservatorship. In many states, guardianship and conservatorship are synonymous with each other. In some states, they are not. They stand for actually two different things. And many states, even in preliminary work that I looked into, in some states, they can be very different. And so trying to get them to work together seems to be a moving trend. Idaho recently passed a law that allows that. Mississippi has clarified notice provided in guardianship requirements to make it comply with the rules of civil procedure. So as you can see, they have to give notice at least 7 days prior to the hearing, and it's got to be served on an adult who resides in that state, and then the court deals with it at that time. And now, as it says here, though, the failure to give notice does not preclude the court from appointing a guardian, but it is a thing that's happening around the country, a better improvement of notice before an actual guardian is appointed. That's one of the bigger trends that we're seeing across the country. Next slide. As you can see here, Washington expands the Uniform Act notice requirements. That's again, notice is a real hot button right now, and there are a lot of changes reading into that. One of the things that they have in Washington, I noted, and I noted this in a couple of other states, is the right to a jury trial. In Florida, there is no right to a jury trial on this issue because Florida, in terms of jury issues, adopted the common law. So only areas where you could have a jury trial under the common law could you get a jury trial. Appointment of a guardian is not one of those. And so in Florida, there is no right to a jury trial. But in the states where there is, that's an important issue. And what rights they get, what rights they don't get when the guardian's appointed is a big issue. Next slide. So temporary and emergency guardianship orders, Anthony talked about that, and other presenters have already talked about these different kinds of guardianship orders that get entered. Temporary ones, emergency ones are an issue that's common. And as you can see here, there's a real, the landmark case, Grant versus Johnson, established certain kinds of constitutional protections as a result of that. So this year, Colorado passed a law which requires the court appointing a professional emergency guardian without notice to appoint a court visitor to interview the person as well. And they have to explain the guardianship in proceedings to the person, interview people who might support the person, the ward, and report back to the court on what supported decision-making options are available. So even though they allow an emergency appointment of a guardian, Colorado has provisions in place to sort of get a better understanding of what's happening before that emergency appointment takes place. Next slide. Again, on this temporary issue, Minnesota has a maximum, and all these are new laws that have been passed in 2020. They've mandated a maximum 72-month term of guardianship for somebody under 30, and then they appoint for an unlimited for a 29-year-old who's been appointed a limited guardian. And Minnesota creates a timeline for that. So they can only extend it once for no more than 60 days. So at that point, either the temporary guardianship expires, or they have to move for a permanent guardianship. So that's I don't say that's necessarily a trend that I'm seeing, although later Sally and Erica can probably comment on that better than I can. But this additional sort of protection before a permanent guardian is appointed is something that we're starting to see around the country. Next slide. Youth transition. We've actually talked about this issue in some of our previous meetings. They file for a guardianship before they turned 18. And as somebody raised in one of our meetings, you know, in Florida, you can't get somebody appointed and then the parents are deemed in Florida, deemed not capable of taking care, and they get a guardian. And then what do you do during the transition? So there are a lot of legal issues about this transition. And every state has different laws and how they're treated. It's a tough one from my reading of these things to make true analogies to Florida and how we would actually use it in Florida because of the way Florida's law works on that particular subject. So next slide. So Mississippi now requires a personal examination of the ward before they can have an extension of the minor to the age of majority. I'm not sure what Florida's status on that is, but I'm sure somebody here on the task force or who's with us today will know. But I thought that was a pretty big change for Mississippi. Virginia, as you can see there, it's between the ages of 18 and a half and 21, and they have to have an individualized program. There's a guardian ad litem appointed in addition to the guardian. So, and as it says, they have to make instructional materials available, et cetera, so they can make decisions going forward after that. Next slide. And the next one I want to talk about is the basis for appointment of a guardian. There's a lot of changes on that taking place as well. As you can see there, Delaware authorizes hospitals to petition for guardianship of non-acute patients. But then it establishes a bunch of procedure that has to take place. Requires hospitals to give written notice, 5 business days, et cetera, to the patient's surrogate, if the patient does not have a surrogate, to the patient's family, et cetera. You know, one of the interesting things, and we're going to talk about this later, that I was struck by in Florida, we've talked about in some of the earlier meetings about how you can have a very detailed set of instructions that you had. You know, for example, you can create advanced directives for medical care. You can create a trust. You can create all sorts of documents in Florida about what will happen to you after you power of attorney. All those things about what will happen to you when you become not able to make your own decisions. But in Florida, because we don't have the Uniform Act, you can go to, once you go to court, and we've had this discussed before, the guardian then assumes that decision-making responsibility. As we heard from a lot of the public comments, that wipes out those previous documents that were executed by the ward. As I understand it, under the Uniform Act, that's not normally the case. Normally, those things that are pre-executed would carry over, and the guardian would have to go specifically to the court and get them waived. But generally, under the Uniform Act, they would stay available. The previously signed things would stay available. On the basis for appointment, again, going back to that, Louisiana now requires a petition for interdiction, which is the state's term for guardianship, to describe the petitioner's efforts to use the least restrictive means seeking interdiction or seeking guardianship. The bill enacts the Supported Decision-Making Act that we talked about before. So again, it's a trend toward supported decision-making. It's a trend toward least restrictive means not being the full-blown guardianship that we often see in Florida. Next slide. Minnesota has amended their requirements to include, as you can see there, this least restrictive means option, which is now taking place in a lot of places. Talks about what has been attempted, why it wasn't successful, etc. So all of that is required as part of the process of appointing a guardian. Before you can do that, you have to demonstrate to the court that you've done this. And then it requires disclosure of whether the guardian has ever been convicted of a misdemeanor or a felony, etc. And they have to disclose they've been convicted of any crime other than a petty misdemeanor or a traffic offense. And then you have to also disclose the rates that the guardian, the proposed guardian, applies. That has to be done before the guardian can be appointed. Next slide. Again, on basis of appointment, Minnesota has this new statute requires a finding the respondent identified needs cannot be met by least restrictive means, including supported decision-making or other healthcare agent or community residential services. So they're sort of setting up this thing that I'm seeing happen in a lot of places, and that is that you only go appoint a guardian when you really have to, that you can't do it some other way. Next slide. Mediation. I'm really not sure how this would work. Mediation is required in Florida in all kinds of different kinds of civil cases. Even at the appellate level, mediation is required. But now Washington has made mediation available to the parties in a guardianship case. And when we talk about this later, I would certainly be interested in see what Sally and Erica have to say about how widespread that is. But it seems, as far as I know, it's not done in Florida, and it seems very different than the typical Florida guardianship process. Next slide. So again, some pre-appointment stuff, visitors and evaluation. Washington provides if they object to the professional selected by the court visitor, they have to provide evaluation by a professional selected by the respondent. And then, as you can see, if they don't participate, then the court proceeds with a hearing, et cetera, et cetera. But the point of this that I really thought this was important is there is a process in place pre-appointment for this evaluation to take place. Florida has the medical team that we appoint, but there seems to be in a lot of states, and Washington is one of them, some additional procedures put in place for evaluation before there's actual appointment of a guardian. Next slide. So the choice of guardian, that's an area where there's a lot of changes going on. So I'm going to run through these quickly. But the main point I really want to make about this is this choice of guardian is an area that a lot of legislatures around the state are dealing with. Obviously, all of these things that we're talking about today are things that the task force might want to consider, might want to look into in more detail, and then see how that would interact with Florida's system before we would do that and make a recommendation to the legislature. But at any rate, Oklahoma defines representative or resident of a nursing facility as a court-appointed guardian. There is no guardian or a relative or other person can be appointed, okay? And then it says owners or employees of the nursing care facility shall not be guardians unless they are also relatives of the resident. Virginia prohibits, except for good cause, the court from appointing the attorney who has represented the petitioner within 3 calendar years as a guardian for the respondent. And employees of the attorney's law firm are prohibited from serving as a guardian. I'm unsure what prompted them to do that statute, but obviously there must have been some problem with that in Virginia, and they decided they didn't want those people serving as guardians. Next slide. Background checks, that's definitely becoming more of an issue in lots of states. Missouri authorizes the courts and Department of Social Service require fingerprinting so they can have positive identification and criminal history information. Mississippi now requires anyone of a guardian, whether they've been in bankruptcy, if they've been convicted of a felony, any crime involving dishonesty, et cetera, as you can see there. So they do not only these background checks, but now they've amended the statutes to really block out quite a few people from serving as guardians in that state. Next slide. So public guardianship. As you can see there, in 2008, they had a national public guardianship study, found 44 states had provisions on public guardianships. And we've got a link to a report there, it's 2017. Can you back up one? Yeah, there's a link there to a report about guardianships and the best indications. Whoops, we jumped around. What happened, Kimberly?
Kimberly, we lost the PowerPoint.
Did we lose Kimberly?
I'm checking. I'm not 100% sure. Hold on just a second. Okay, looks like she's loading it back up. Sorry, I don't know what's the technical issue, but just give her a second.
Well, while we're doing that, Sally or Erica, do you have anything in particular to say about some of these issues we've talked about already?
Well, I don't know if Erica is yet on, but
I think I saw her sign in, but go ahead,
okay.
Sally.
So, Erica, are you here?
I'm here.
Okay, so this, I'm not quite sure which one of the many issues you've already covered, and there are also so many others. Just a few points. One of the, let me start with, why did Virginia pass the law most recently prohibiting the petitioner's attorney from being appointed as guardian in that case? We had one of those headline cases in Virginia where an attorney was being paid by the hospitals as well as the nursing homes, and kind of petitioning on behalf of a hospital to place the individual out of the hospital into a nursing home. And it was definitely a pipeline with a lot of conflict of interest. And as a result of an excessive use of the attorney for the petitioning hospital having himself appointed as the guardian to make placement in a nursing homes that he also had a financial relationship with. So that was the reason for that Virginia statute that you were just mentioning. Several of the other items that not only the importance of less restrictive alternatives and trying to find ways to make sure that guardianship is essential and necessary is definitely a theme that we're seeing throughout the legislative reforms, not only last year, but in a number of years. So it's the pipeline issues, I think, both with the transition of young adults who are transitioning out of minor guardianship into adult guardianship, and the need to have a lot of education and safeguards in place so that it's not just an automatic, you were under guardianship as a minor, so therefore you need a full guardianship going forward, whether it's your parents or someone else. As well as the pipeline issue of of hospitals petitioning for a guardian to make a rapid transfer into a skilled nursing facility, which may not be the most appropriate placement. So I think the overall theme is putting in guardrails or safeguards to make sure that the guardianship is carefully considered and that the guardianship is tailored to the specific needs of the individual, and it preserves as many rights to the individual as possible. And that's also sort of the same thing with the safeguards and guardrails being put in around emergency temporary guardianships, that it's really an emergency and it's really temporary, and that there are safeguards or guardrails to make sure that the emergency temporary is lightly applied instead of sort of, I'm in a hurry, so therefore I'll do an emergency.
And I'll add two things too, and I'll just ditto everything Sally has said. But I did want to clarify for a moment about the Uniform Act. So recently, the Uniform Law Commission has authorized 2 uniform acts. The first one that you referenced was the Uniform Adult Guardianship and Protective Proceedings Jurisdiction Act. So that doesn't touch substantive guardianship law. It's only jurisdiction. And in order for that to work, obviously it has to be adopted by all or most of the states. That was a lot of hard work by the states, but all but 4, as you said, adopted it. It's only jurisdictional in nature. Then in 2017, the Uniform Law Commission updated its old Uniform Guardianship and Protective Proceedings Act. I know this is a lot of words. It authorized the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act, and that was in 2017. Slowly, the states, I think we're up to 3 now. And some states have picked up pieces of the Uniform Act, so it's not an all or nothing thing. But I know that it can be confusing with these different uniform acts. The only other thing I wanted to say right now is that Tom's doing a super job of going over the 2020 legislation that covers that particular year. If you go to the ABA Commission on Law and Aging website, you'll see for any particular topic charts done by not only the ABA, but our wonderful partner, Sally Hermy, that give you an overview, like let's say right to counsel or emergency guardianships. There's a whole chart, detailed chart on exactly where all 50 states stand as of this moment, or well, as of the last updating of the chart. So I just wanted to set those 2 things in context.
Well, thank you, Erica, and thanks for that clarification. You know, I was aware of that and somehow just got lost when I was talking about it. But and in the source article, it really makes the point about why the Jurisdictional Act is important, so that and particularly it struck me to Florida, where you have so many part-time residents. I did work when they were adopting the Electronic Will Act. Florida was, at least what everybody understood anecdotally, there were more lost wills in Florida than any other state, because families were pretty sure their father or mother or somebody who passed away had a will, but nobody knew where it was. And it may have been in their other residence, that sort of thing. And jurisdiction over with Florida not being part of the jurisdictional act, it does create some problems. So with that, thank you both very much, and we'll go back to the general PowerPoint slide here and move ahead. So as we were talking about public guardianship, Colorado has this new law which requires the Office of Public Guardianship to request the Colorado Adult Protection Services check before hiring any new employees. So again, a lot of background checks trying to make people who are doing these guardianships, that sort of thing, do not have a bad record and really have the best interest of the ward in mind. Next slide. Florida, I've included Florida, which was passed last year, requires the court, prior to the amendment, the court had discretion to waive the court costs for certain proceedings involving public guardians. Indiana requires volunteer people, programs to submit a care plan and progress reports to the court. So these are all public guardianship amendments that are taking place. Next slide. Guardian actions. This is another area that we're going to talk about. Next slide. The guardian's power of authorities, as you see there, Idaho authorizes the guardian to sign on behalf of a petition for annexation of land in a flood control district. One of the things that I did not include in this, because, and you'll see if you look at the source document and a lot of other things, is this issue about transfer of land. That varies widely from state to state. Laws about processing and selling property, real property, are so different state to state that every state seems to deal with that in a very different manner, just as they do with generally the sale of land in their particular state. Some states, it's very easy or easier to transfer land. In some states, it's very hard. And the same with guardian. They seem to deal with it differently every state. And then, as you can see here, Maryland has passed a law that allows government entities to deliver notice by electronic means on these various things. So it's, again, as we were talking about, there's more and more protections in place, but also they're trying, it seems to me, they're trying to have better ways to provide notice to people as well, so that everybody's fully informed about what's going on. Next slide. There's a whole bunch of these, as you can see here. Minnesota has a statute that did a couple of different things. Non-professional guardians can delegate some of their powers by power of attorney, and professional guardians can do theirs for up to 30 days. They can't do it for the power to consent to marriage. Interesting exception. Minnesota authorizes the governor to establish but not administer an able account for the person. They can exercise all that powers. Standard of fiduciary is same as all those accounts. So they've dealt with some of these issues about how much authority they have, what they can do, what they can't do. And a lot of this is local to particular places, but it's something that we certainly ought to think about as we move forward on the task force. And then, interestingly, Mississippi requires the guardian or the conservator to take an oath to faithfully discharge their duties according to the law. And I'm not sure where we stand on Florida. I'm sure there's other people here listening today know what that is, but I don't know if they have to do that in Florida or not. Next slide. Again, this is that same statute for Minnesota. They had a pretty extensive a bunch of changes last year. As you can see, they can move, have an expungement case, which I found interesting. They can bring a harassment suit. They can basically do everything they could do if they were the person, as I read it. They can act to do virtually anything that the person individually could do. There doesn't seem to be any limitation on that. And then certainly it seems to be a big expansion over what authority they had before. And the bill also clarifies if a person has a job, the wages are not paid to the conservationship estate. They're still paid directly to the person and shall be in the person's control as if the conservatorship did not exist. And they don't have to account for those wages and salaries. So I'm not sure, and I'm sure Eric or Sally maybe can help us on that later about why that was different and why it seems that they have two separate accounts that are going and why they thought the need for that. Next slide. And as you can see, there were a lot of changes on this power of authority in this past year. Oklahoma has now clarified the limitation on the guardian's power to consent to withholding life-sustaining procedures. You know, we're all familiar with the do not resuscitate case that got so much attention in Florida. And the court has to do that in a separate order. And they can only do that at the time they need it, as opposed to, I'm assuming, as opposed to ahead of time. And they have to make specific findings of fact and conclusions of law. So it seems to me there's definitely that's going to be a much more court-centric procedure in Oklahoma after the passage of that law. And it looks to me as if the court's going to get involved a lot of the time. Washington created a new process for conservators to access assets held by financial institutions, as opposed to sometimes those financial institutions are charged with running those accounts, and this seems to say the conservator or the guardian is going to then have the authority to do that. They also passed a law establishing rights for the clients of the state's developmental disability agency. The client's rights are exercised by the guardian as subject matter within the scope of the guardianship order. So again, there's dealing with how agencies interact with the guardian. This seems to be an important process in a lot of states. Next slide. And then authority of agents versus guardian. This is another area where there's a lot of differences between the states, at least based on the reading that I've done. Florida seems to be different than a lot of them. And so just in general here, you can see, I'm not going to read every one of these, but you can see these kinds of things that either an agent or the guardian can do. In most of them, as you can see, power of attorney trumps the authority of the guardian, as we've heard here. Generally, that's not going to be the case in Florida. Once a guardian's appointed, those power of attorney and other things get wiped out pretty quickly.
If I could just, Mr. Hall, and thank you so much for this. Obviously, I mean, this would be a big topic for us to discuss for legislation, that the power of attorney really, and the healthcare surrogates are always at the beginning of any proceeding, whether it's an emergency, an ETG, or a regular guardianship proceeding. The advanced directives are always thrown out. I mean, to me, it's almost like we should be recommending to everyone who's about to get these documents not to do it, not to waste your money, because they are just basically thrown away like trash. So I'd like to put that in our notes, that the advanced directives, I think there really has to be more in whatever the statute is, 744 or 745, that says that the power of attorneys cannot be thrown out in the healthcare surrogate unless there is proven exploitation.
Okay.
Can I intervene for a moment?
Wait, please, hold off, please. Hillary, our protocol today is we're going to have the presentation by our experts, and then we will open it up to our task force members to comment and ask questions. So I'm going to ask everyone respect that. I did let you go on there, Hillary. I probably interrupted, but if we could just observe that protocol, well, I'm sure we'll have a robust discussion, and also make the best use of these experts we can ask questions to, which I hope there's a lot of questions. Thank you.
Thank you. So next slide. And again, here's some stuff on this difference between agents and guardians. As you can see here, there's a Uniform Power of Attorney Act, and that Uniform Act terminates the power of attorney upon appointment of a guardian. Kentucky provides the nomination in the power of attorney, specifically says that when you're doing a power of attorney, you provide for the nomination of a guardianship or conservator. And as South Dakota adopted this year the Uniform Power of Attorney Act. Next slide. Guarding access to digital assets. It's an interesting issue. I didn't realize that there was a different treatment of digital assets and other assets before I started looking at this particular thing. But as you can see this year, 2 states have adopted that revised Uniform Fiduciary Access to Digital Assets Act. One of the things that I was also struck by in sort of pulling together some of this, and when I started really working quite a long time ago when I agreed to help staff this task force, was how many different uniform acts there are relating to all aspects of what guardians deal with. And there are a lot. In Florida, we have the Electronic Will Act now, which has all kinds of provisions that have to be followed before you can do an electronic will. And I did not realize that it was so widespread that there are these uniform things. And I don't know where Florida, personally, I don't know, and I'm sure that some of the other people do, where we stand on all these uniform acts. But I think that's something that the task force probably ought to look into as we move forward. Next slide. Post-death authority. Kentucky authorizes a guardian to make burial plans if a family member or individual is not available. And interestingly, they can arrange for cremation, but only under certain circumstances. So the guardianship extends even past what would normally end the guardianship, and that's the death of the ward. Next slide. Fees for guardians as attorneys, and as you might imagine, this is a hot button issue going around right now. It certainly is an issue in Florida, and as you can see there, it's a big issue about bringing a guardianship, and it's a big issue that often arises in the guardianship itself taking place. Mississippi exempts the guardian from obtaining an attorney of record for guardianship if the court finds the fees would place an undue burden on the person's estate. Very significant change, it seems to me, for Mississippi and lots of other states. And then Virginia, another interesting, and this may be one of those guardrail or pipeline issues that we were talking about before. If the medical care facility petitions for guardianship, they can order reasonable costs for the guardian be paid by the petitioning facility instead of the ward's assets, which is a very interesting provision. Next slide. Rights of individuals. This is an issue that we've talked about certainly in our meetings we've had before. So next slide. Right to visitation, and again, we've actually had a lot of public comment on this. It's, as it says here, there's it's complex. There are often family issues involved, undue influence, and all those sorts of things at a time of things that can be raised. And again, there's another standards of practice that is supposed to be followed, and that is the guardian shall encourage, support the person in maintaining contact with family, friends, etc., unless it substantially harmed the person. So again, there's a national standard which applies in these kinds of situations. Next slide. And you can see here, I'm not going to read through all of this because it'll be available to us, and we're running a little short on time, and so I want to make sure we get through all of this. But again, there's some things that really need to be looked at about rights to visitation in association with the ward, and that in Florida, that's going to fall on the guardian. But again, those are the kinds of things that really need to be taken into account. Those are the kinds of things, as we've heard already, can cause a lot of great problems during the guardianship. So again, that's an area I think the task force really wants to look into. What does Florida law provide Are we really meeting the national standards? Are we really working to give the ward more say in their own sorts of things? And that includes visitorship. Next slide. So as we point out here, there's an in-depth, we've got a link to an article. There's an in-depth article on this from the Commission on Law and Aging that was done in 2018. I read it through. I read most of it in great detail. There's a lot of detail in there. And one of the reasons there's a lot of detail in there, as we just discussed, it's an area where there's a lot of problems during the guardianship and a lot of heartache for people. And it's the same law that Minnesota that we referenced before that was passed last year. It definitely expands the right to visitation, communication, all those sorts of things, interaction with the ward. So that's another area that Minnesota last year did some pretty comprehensive changes, and they dealt with this particular issue as well. Next slide. Bill of Rights. I was not aware of this, but many states have specific provision listing the rights of the individuals who have a guardian, and that includes Florida. And you can see the other states that do there too. Florida actually is pretty good on that compared to a lot of other states. And then Minnesota, again, in this bill last year, they updated their Bill of Rights. They increased emphasis on the person's preferences, and the person's preferences is definitely a real trend. The co-decision making, all those sorts of things, there is a lot more emphasis on the person, even though they are a ward and they have a guardian, of them being able to participate and that their preferences be taken into account. So Minnesota adopted some pretty significant changes to their law last year. Next slide. And here's some other provisions. Again, this Minnesota bill from last year dealt with a lot of these things. It removes their confidential financial and health information from the petition itself to a separate document, and that document is kept confidential. That's actually stayed right now. The state courts objected to that. It's interesting in Florida, that would not be controlled by the legislature, even though the legislature has the right to make public documents exempt from public disclosure or confidential. Well, there's actually a constitutional question about whether after Article 1, Section 24 was amended, whether the legislature has the right to make a document confidential, public record document confidential, or just make it exempt. But we're not going to get into that today. But at any rate, there's a series of cases from the court system saying that once those documents reach the court determines what's confidential, not the legislature. So I suspect that, and although the court in Florida would not raise the issue themselves, if there were confidential questions, the litigants may raise that issue, as they've done in lots of other court cases. And Virginia requires the court to again, as it says here, to say that they can take part in the decisions, they can act on their own behalf. If they develop or maintain the capacity, they can do these sorts of things. And it sets out specific language that has to be included in all orders for appointment of a guardian regarding decision making. Next slide. Changes in terminology. One of the things that I found difficult in reading all this material and trying to put this slide presentation to go, and including through the source document, is different terms are used in different states for the same thing. For example, Britney Spears case we've all heard about, that's a conservatorship. But as I understand it, that's the same thing as a guardianship in Florida, where in some states conservatorship does not mean that. So many states are updating that language. One of the things that I think we've talked about it in some of the meetings. I know that I've in some meetings in previous years talked about this. Even the use of the term ward is as it says here, and under the Minnesota Act is a term that's not as favored as it used to be, and that may be something we want to look into in Florida, then Minnesota changed it to person subject to guardianship. Next slide. Capacity issues. So next slide. And as it says here, it's done a lot of different ways in a lot of different states. And we've talked about this extensively. We had one meeting where we talked about it quite a bit, that determination of capacity. But just quickly, some of these, Maryland adds a nurse practitioner to the list of people who can sign on the certificate of incapacity or guardianship. So it would currently require 2 physicians or 1 physician and a psychologist, licensed clinical worker, or now a nurse practitioner may sign. Minnesota added licensed physician assistant to the list of people who can do it. And Washington just simply removed that language altogether, references to legal capacity. They took that out when they adopted that Uniform Act. So that's the quick summary of all of this. At this point, we are going to open it up for questions. I would turn that back over to our chair, Mr. Burke, to discuss how we're going to handle the questions. And we were definitely going to direct a lot of those questions to Sally or Erica to answer. But Clerk Burke, I would, however you want to handle the questions at this point and recognizing who's going to speak, I'll turn that back over to you.
Thank you, Mr. Hall, and thank you for that well-researched presentation. We certainly appreciate the 2 national experts, Erica Wood and Sally Hermy, being with us. Let's start with questions, folks. And I would ask you not to make a speech, but to actually ask a question of our experts. We can get into comments after the questions are done. And Sean or Kimberly, can you tell us, or I can see y'all, if someone wants just to raise their hand, I will recognize you for a question. Okay, Shannon, go ahead, please.
Thank you. I want to talk about the Uniform Jurisdiction Act for a moment. And I know that was our experts were really kind of honing in on the importance of adopting the guardianship jurisdiction problem that we have in Florida. And we have now, the Elder Law Section has proposed adopting the Uniform Jurisdiction Act in the guardianship statute several times, and it's not passed in the legislature. So I wonder, from our experts, Erica and Sally, can you explain why that is so important for guardianships that exist in other states? For example, I had a case recently where I had a client who was on vacation in Maine, and they would not honor the guardianship orders from Florida because we don't have that reciprocity with regard to jurisdiction. And it was incredibly difficult because she needed to be in a hospital and we couldn't get things done without doing a guardianship in Maine. So I wonder if you could just speak to that issue a little bit.
Well, I'll begin, but Sally can also tag on because she spent a lot of time on that Jurisdiction Act. But if you look at the Jurisdiction Act, you'll see that it has 3 key sections, and those are jurisdiction, that is what one would call which state. More than one state is involved in this case. Which state hears the case? And before the act was passed, you have a lot of problems with states both wanting it or neither wanting it or not knowing which went first. And it was extremely confusing and wasteful of a lot of resources and caused a lot of angst. The second one is recognition, which you did a great job of explaining that a guardianship, if a guardianship is not honored by another state, there can be severe consequences, particularly when somebody is in that other state for a temporary period of time, and that can be recognition for needed health care, for financial matters, or whatever. And then the third thing is the registration.
Transfer.
The guardians can quickly, the act provides a process for guardians to quickly register. In order for the guardianship to be recognized, you can register that through a process that's much less burdensome than guardianship.
But I think that it's so important because it has to do with jurisdiction and which court has the authority, or how a guardianship can be picked up from one state and moved to another state, or how an order by a Florida court can be recognized without having to repetition for guardianship, when all it is that you want to do, let's say, a single transaction or something that has to be done out of state. And with Florida being one of the primary snowbird states, with lots of people spending part-time in Florida and part-time somewhere else, they may have property in Florida, they have property somewhere else. I think it really is essential that Florida join with the rest of the states to smooth out these unnecessarily complicated issues, because there are no guidelines. The Jurisdiction Act doesn't change any state's law. It really just makes it easier for the courts to communicate, for the courts to work together to figure out which court is going to proceed. It saves lots of resources for the individual subject to guardianship, because they don't have to pay court fees multiple times for unnecessary reasons. So I don't know why the Florida legislature has been dragging its feet in joining so many of the other states, because Florida is the locus of a lot of those problems to begin with.
The next question is from Mike Donovan.
Just a real short one. I read Florida statute to say if I'm an attorney for a ward, I cannot be that ward's guardian ever. It's not 3 years, it's ever, which sounds pretty reasonable to me. Would the Uniform Act change that?
No, the Uniform Act does not. That was only a Virginia law that was necessary because of one particular sort of bad actor.
Well, it sounds like the Virginia law is much less restrictive than the Florida law.
That's probably as much as the Virginia legislature was able to go. Florida's statute is much better.
Okay, thank you.
Yep, I've got a question.
One moment, please. Michael, did you have a question? You're, I think, next to be recognized, and you have to take yourself off on mute.
Clerk Burke, thank you so much. My question is about supported decision making. Because of my story, there are a lot of cracks in the guardianship system here in the state of Florida. Like when I resided in St. Lucie County and had my rights taken, I felt like, I don't know, like, how does the examining committee in the court system get picked? And is there a list of examining committees that are approved by the court to examining those individuals that is being basically having their rights taken? Because I think that is where the major problem is the examining committee. Like, for example, if I didn't have Dr. Sugar, which was my examining committee when I was in the guardianship and got my rights back, I would have never been in supported decision making. And I feel like that's where most of the cracks are.
Thank you, Michael. Erica or Sally?
Yeah, I'll say a word about that. And I'm not an expert in your examining committee, but I think that one idea here would be that the examining committee or the investigators in some states, or the guardians ad litem, or the court visitors, when they're looking at the individual's abilities and limitations, that they take into account supports. So if the individual has a person who's helping them, so a supporter, that might, you then might not need the guardianship, and that's, you know, the supported decision making could be a less restrictive option. Now, in some cases, some states have provided for recognition of supported decision making agreements, so that's kind of a step further. But I think the basic thing to me is that the court and the examiners take into account those supports and dig to see if those supports are there or could be put in place.
Sally, do you have anything to add?
No, I think that pre-examination process, whoever it might be, in Florida, it's the three-person examining committee. It's somebody else with somewhat different title in other states, but I believe that it's incumbent upon them to look for less restrictive alternatives. And I just want to put in a plug that I think that advanced directives and financial powers of attorney are also less restrictive alternatives. And I would encourage you to have statutory language that would allow those self-selected decision makers be honored unless the court specifically finds that there is some abuse or misuse by the agent that has been personally selected by the individual to abrogate automatically those powers of attorney or advance directives. I think goes against the very strong common theme to allow the person to make their own decisions and pick their own decision makers.
Senator Bradley, I think you had a question. You're recognized, please.
I did. Thank you, Ken. And this question is with regard to the uniform jurisdiction issue that we talked about earlier. And maybe it's for Shannon Miller or whoever else can enlighten. Shannon, you indicated that the elder law section had recommended the adoption, but it never got across the finish line. Was there a particular resistance? Is there an objection? What was there a concern? Did it just not get over, or what roadblocks were? Why was that, if you're aware?
I am, and the basic concern, I believe, came from another section of the bar. Sorry, Sancha, but it was the reptile section. And their concern has repeatedly been that it isn't necessary, that there is not a need to adopt the Uniform Jurisdiction Act. And I don't want to state for them, and maybe Sancha has more insight into it, but honestly, we've been trying to get this across the finish line for a long time, and that has been the primary objection, is that any change that's made where we would somehow like make our guardianship laws, adopting the Uniform Act, that it somehow lessens the effectiveness of Florida's guardianship laws. And I would also say, related to the less restrictive alternative that was just raised, Florida's laws do provide that courts must honor durable powers of attorney, designations of healthcare surrogate, and living wills. That is statutory required under 744.331. The court actually has to make findings of fact on that, and also 744.3115. So I just wanted to clarify that is in our law already. But with regard to the Uniform Jurisdiction Act, we think it's time. And again, we're left, and everybody in the nation knows that Florida doesn't do it. So now when it comes across another state judge's desk, they know that Florida hasn't adopted the uniform jurisdiction laws, and they are really kind of making it harder for us as practitioners to it used to be that it wasn't hard. You got into another state, your client was there, judges didn't understand about the Uniform Jurisdiction Act, and they would just let those guardians operate. But now, because it's on everyone's radar that Florida's one of 3 states that hasn't adopted the Jurisdiction Act, I think it's really becoming quite an issue for other judges in other states saying, we can't honor it. You don't have reciprocity with us. You won't honor ours, so we're not going to honor yours. So it is problematic.
Viviana, you're recognized.
Thank you. I just wanted to add that I'm looking forward to the conversation about supported decision making. Mike and I are the co-chairs of a coalition called SDM for Florida that includes a bunch of disability advocacy organizations and people directly impacted by guardianship in Florida. And we had a bill that was introduced last session. We're hoping to have it reintroduced this session. And I think it's something that goes really well with what we're working on in this committee. And I was encouraged to see that supported decision-making was recognized as one of the where we're moving toward in guardianship. And Mike, as the first person in Florida to use supported decision-making, has, of course, a lot to add there. I also just wanted to clarify quickly that with supported decision-making, the people that help you make decisions are the supporters, not the decision makers. The person with the disability is the decision maker.
Thank you, Viviana. I have a question for Erica and Sally. In the state of Florida, a judge, when they're appointing a guardian, has no database to look to as far as how many guardianships that person currently has assigned. Some of the judges may ask them that question, but there's no independent database. There's no database which shows how many they've closed out in the past few years. Maybe they've been taken off. There's no database as far as anything about that guardian, information like that. There's no database which shows maybe is there a trend of a certain attorney, for example, like you mentioned with the pipeline from a hospital or to a nursing home, anything of that nature, or even financial information maybe that can be relevant to the court and helping them to protect those folks who are put into guardianship. So my question to y'all is, do you know of a state that has a system that's a statewide system with a lot of data in it? Because in Florida, we have no system.
Sally, you start off. Sally has just written the most wonderful, up-to-date, comprehensive paper on guardianship monitoring and data collection. So take it away.
Well, data is near and dear to my heart, and the need for it and the lack of it throughout. Actually, Florida is doing a much better job in collecting some data about guardianship, who has been appointed, et cetera, et cetera. And you should be proud of the progress that has been made in creating case management systems and the technology, at least in parts of Florida. Many states are further behind than Florida is in being able to have information about any significant component of guardianship: who's under it, their age, why, who's serving as guardian, how much assets are under guardianship management. There's a dearth of information, but gathering information about how many cases any one particular guardian has been appointed to may be available within one county, but if they are appointed in other jurisdictions, I don't know how the courts in Florida currently would be able to have that information. You, of course, have the ability to know who is registered and who has, as professional guardians, through your Florida elder law registration system for guardians, professional guardians. But I don't have an answer for you, and you are not alone in wanting to have more information so that you can set policy, so that you can understand where the needs are, what the growth is, where more resources need to be allocated to the courts. So data is very important, and I'm not sure I know of unless it's Michigan,
Minnesota.
Do you think Minnesota has the data points on how many cases any one individual guardian has?
I'm not sure about that, but Minnesota has a very probably the most sophisticated data system in the country, and they do require guardians and conservators to e-file, and then they are able to do some analysis of those e-filings and look for red flags and get back to the local judge about what they found. And that's very unusual, and that gives them a picture of guardianship in their states that most states don't have.
And of course,
I'm sorry.
with Florida's giraffe, you do have that capability, and perhaps Anthony Palmieri can speak more in greater detail as to what data points Florida, or at least Palm Beach County, is able to provide.
And Sally, we're going to save that because we have him scheduled for a future presentation here.
All right, fine.
So thank you on that. Karen, I believe you had your hand up. You're recognized, please.
Thank you, Ken. I just wanted to ask our experts. I know that Tom mentioned that Delaware this past year created a statutory provision for hospitals and medical facilities to petition for guardianship. And that is one of the areas that we've discussed we want to look at as a task force. Are there any other states that you would point us to that have analogous laws or maybe even better examples of how this process has been codified?
You know, I was a little confused by that law, and I should say, just with the caveat that this 2020 piece was done after I retired, so I didn't do that one. I had done the previous ones back to 1988. You know, what I know from looking at the laws across the country on who can petition, usually any person, and person is read to include entities, usually any person with an interest in the person's welfare can petition. So I wasn't sure of the you know, we think back to our earlier discussion about the pipeline and the hospital to guardianship pipeline. I'm not sure why they needed to authorize hospitals to petition. So one would have to ask a Delaware expert on that.
And I would like to add that I would like to add that during the 4th National Guardianship Summit, which was held during the month of May, well, in May of this year, one of the background articles focused specifically on the issue of the nursing home, hospital nursing home guardianship pipeline. And there are statutory references. And I think that would be an excellent place to go to get the most current research on how to manage or what the problems are or the guardrails that should be in place with hospital petitions.
Hillary, you get to ask the final question here today.
And I'm, you know, I adore you, Ken. I'm just going to make a comment about hospitals and guardianships. As we speak, there is someone in a guardianship that the hospital, through whoever they outsourced to, was put into a guardianship. The guardian is making $75 an hour, is being isolated from his family member who is begging to be his guardian. And at the bottom of the, I would think it's the magistrate's report in bold, it says if no funds are located, the hospital, Baycare, will provide compensation to the guardian at her hourly rate for the life of the guardianship. This gentleman is 52 years old. How does he have a chance of getting his rights restored when that guardian will be paid for 50 years, I'm exaggerating, at least 20, 30 years? The hospital petitions, we understand it's because of liability. They want these patients, stuck patients, as Teresa Barton would say, out of their hospitals, but it's a big worry. As an advocate, it's a big worry. Thank you.
Thank you, Hillary. Sally or Erica, would you care to comment on that topic?
To me, what I go back to is the discussion about fees, and Tom mentioned that earlier. And I mean, one thing. But if you look at the things that came out of the summit, and if you look at the Uniform Act, you'll see that there has been some attention to fees, and that there's some dawning recognition that courts up front have to do more work in asking questions about fees and the reasons for the fees and the limitations on the fees, instead of making that kind of flat statement. So I think that in any reform, that fee piece has to be taken into account. And if you look at the recommendations that came out of the third National Guardianship Summit in 2011, you'll see a whole piece on fees.
And I would like to also add that one of the focus areas within the fourth National Guardianship Summit was on the need for access to the courts for complaints or grievances to be heard. There are a number of states which have simple web-based processes whereby anyone with an interest in the individual who is subject to guardianship may raise their concerns to the court, and the courts have protocols by which those grievances can be heard, whether it's by a magistrate, but somebody has to take a look at the grievance. And another recommendation from the fourth National Guardianship Summit was to ensure that there is some form of periodic review, whether it's every 3 years or every 5 years. There needs to be the opportunity for the case to come back to the court, for the court to understand whether the guardianship needs to be continued, if it needs to be modified, and if there are any issues that the court should address. So that periodic hands-on look at the individual, I think, would resolve a lot of the problems about guardianship seeming to last forever when there has been a significant change in the circumstances of the individual, as well as an opportunity for the public to raise their hand before the court, so that the court can understand if there is an ongoing issue with any kind of guardianship, to make it easier for public access to the courts. Of course, yeah.
I want to thank Sally Hermy and Erica Wood. I'm glad both of you are failing retirement. It's so kind of you to volunteer your time to be with us today and to provide the insights from a national perspective. I certainly appreciate Tom Hall putting the presentation together with Kimberly. And Tom, I think you have some concluding remarks you would like to make before we open up the public comments. Tom?
Yes, just real quickly, if we could get the slide back up, we have the web address where the stuff is going to be posted. If not, we can, it's the same web address we've been using before, but we're going to post both the PowerPoint and the underlying source document, which was the ABA report. If we can't put it back up, we can make sure we get that out, and we'll get that information out as part of the next announcement maybe. But it's the same web address we've been using, and Kimberly just put it, or Sean just put it in the chat so you can get it there. He gives the address. We'll post both of those documents there, so they'll be available. And as I said before, they include a very comprehensive table about all those last changes. Thanks, Kim.
And just for those that are participating via YouTube and do not see the chat, it is www.guardianshipimprovementtaskforce.com. And again, all documents from all past meetings, as well as the recordings of the presentation, are located on that same website.
Thank you, Kimberly. Shannon, you have a concluding comment because we do need to get to public comment, okay? Could you make a
I
brief-
do. I'd like to make a motion before we get to public comment. And I'd like to make a motion that at a future meeting, we hear from a court-appointed attorney who's a private court-appointed attorney, from a court monitor from Broward County, and from a family guardian who has been a family guardian in a guardianship matter. And I will submit this motion in writing, and I believe Sancha is going to second my motion.
I would second as well.
Okay, are y'all for adding a special meeting to have this? Because we don't have a, it looks like our programs go through the September 22nd. We already have a court monitoring panel that's coming with our September.
Perhaps we could add that to that meeting. We could just add on to your court monitor program. Maybe we could add just like 10 or 15 minutes for a family guardian and for a court-appointed attorney to share their experience and answer questions.
The court and Shannon, we're going to do this, okay? So, but according to our rules, a motion's supposed to be delivered before the meeting, okay, and put it as part of our agenda. Is everyone for this? You could shake your head. We're just not going to do it as a formal motion this way. We'll just go ahead and good. Okay, we're doing it through consensus method rather than the formal motion.
Thank you.
We will do that, but and I hope you're, you know, with the court monitor, we already have asked people to so I'm not sure if that Broward's part of it. Anthony, are you still on the call? Is that person as part of this? Anthony, unmute yourself if you can.
I don't see him.
He's here. He's just not. He's on the phone rather than here. He is. Go ahead, Anthony.
Sorry, I had myself on mute. It wouldn't be 2021 without doing that. So no, we have several court monitors, but not the one from Broward.
I'll be happy to provide her name and information. I just talked to her before the meeting and she said she'd be willing to come and provide information about being a court monitor on the wheel using the administrative order that has become very effective in Broward County. I'd like to share that information with the group.
Okay. And I know court monitors are all over the place, have different responsibilities, have different methodologies. So it would be good to hear from a group of different ones. So let's move on with our public comment. If anyone has public comment, please chat in the room that you wish to make public comment. That'll be the easiest way for me to do it. With public comment, you cannot be anonymous. That's one thing with public comment that is recognized under the Sunshine Law. You do have to identify yourself and give your name. So we will only recognize people who have given us a name for us to call. We have two that I have on my list. And the first is Geraldine Lambo. And after Geraldine, we have Dr. Sam Sugar. And so Geraldine Lambo, you are now recognized. And again, if anyone else wishes to make public comment, please put it in the chat and I'll add you to the list.
And just as a reminder, I have the timer and I will tell you when there's 30 seconds, 10 seconds, and time up. And also if you have the YouTube stream open, please close that before making your public comment. Thank you.
And you do have someone on the phone who wants to make a comment also.
Hi. My father is 92 years old, was diagnosed with dementia in August of 2019. He is now isolated and has been for the past 2 years from his family. While I still have DPOA, those responsible for this are a local ex-politician who is also a retired doctor and who is now on Florida's 2nd District Judicial Examining Committee. His wife, who is my father's guardian now, and also a well-known attorney who did my father's original estate papers. These three conspired together to manipulate and take advantage of my dad's vulnerable state by placing him into a voluntary guardianship. They revoked my DPOA without proper notice, removed my dad from his home, changed his estate documents without due process, thus gaining full control over my dad and his estate, naming the ex-politician's wife the guardian and the executor of the trust. They have gone through his investments and are now trying to sell his property, which includes his home in Wakulla County. We have been fighting this in court for 2 years now. First, we had lawyers. Now we're doing it pro se. They have villainized the family, and of the many lies they have said about us, one claiming we have all stolen from my father. I was arrested for stealing my mom and dad's vehicles, vehicles which I have never had. When this first started, I suspected no good of them. Through the encouragement of my family, I put the vehicles in my name so they could not sell them, which is part of the responsibility of a DPOA to protect my father's property. Recently, they also put a large trash can in front of the house to start fixing up the house, all without permission from the court. It was removed when we put a motion in the court to stop this action. The same group took 2 years prior to put my mother into a guardianship. However, she passed away 3 weeks later. To me and my family, it looks that my mother and father were targeted by this group. We have done our research and have found they have done this to others. It is very shameful that the powers to be of the Florida state to allow this to go on, and it is my hope and prayers that this task force will change the laws for the good. I thank you for letting me speak.
Thank you, Ms. Lambeau, for being with us. Dr. Sugar, you're recognized. And after that, Mr. Rick Black.
Thank you very kindly, Ken. I appreciate the opportunity of taking part in this again. First, I'd like to say it was a pleasure to listen to Sally and Mr. Hall and everyone else who presented today. And if you ever wanted an education about guardianship in the United States, you just missed a great one. So thank you to them. Currently, we know that there's massive interest and attention being paid to this very broken system. The existence of the task force itself gives testimony to the fact that there's an urgent need to make urgent changes. I think it's really important to encourage the group to continue, especially in light of the challenge that's been thrown down by the Guardianship Association, by the FSGA. I think this work is critically important and it needs to continue, as does other avenues of approach. But I think it's also important to understand that as someone who's observed this for a decade, this system is broken. It is excessively paternalistic. It is frankly unconstitutional against the 14th Amendment. And it is an asymmetric system in which an individual who was a functioning member of society yesterday, by tomorrow will be completely dependent on a system that simply does not work well when money is involved. The issue of alienation and isolation is a critical one, and I would urge, rather than hearing endless stories, because there are endless stories, and I'm very familiar with Geraldine Lambeau's case, and it's awful, as was mine, as were hundreds of others. I think the challenge for the committee is to stay focused and to try to reach their goals, which should include removal of the financial incentives in guardianship. That may be the hardest thing that you could ever do, but it would be the most significant. If you take away the financial incentive to create guardianships, to extend guardianships, and to maintain them over decades sometimes, you will have done a wonderful job. If you, for example, would make legal and guardianship fees part of the budget so that at least they would be transparent. You know, currently the budget does not even talk
30
about
seconds.
fees. Yes, thank you. Improving the access to the court is obviously critically important for the public, for which all of you work. Let's remember that the public is your boss, and you need to listen, and the courts need to listen. I want to thank you for your attempts to fix this
10
horribly
seconds.
broken system, and I hope you'll be successful. Thank you very much.
Thank you,
Thanks,
Dr.
Sam.
Sugar, for your remarks. Mr. Black, you're recognized, and then Susan Melende.
Thanks, Ken, and also to Erica and Sally, who I've had the pleasure of meeting many times over the last few years. Thanks to the FSGA and members of the task force who in yesterday's report on ABC News confirmed Florida's adult guardianship system is broken. Sadly, the legal community who controls the affair and its most predatory members continue to say the system in Florida works great and just needs more secrecy. This week, one of your members had the chance to protect Ward Christine Legiskay, 92 of Hillsborough County. Christine is lucid and living fully independent in her home on July 14th, when her son Pierre, who lived next door, filed an ex parte guardianship for him to be guardian over her. On July 16th, Hillsborough County Probate Court Magistrate Sean Cadigan on the task force and Richard Weiss ordered professional guardian Susan Whitney as Christine's plenary ETG petitioned by her attorney, Gerald Hemnes. Pierre's attorney, Ying Gao, and Christine's court-appointed attorney, John Hackworth, worked with Hemnes and Whitney to execute this ex parte, involuntary, and unnecessary guardianship. No notice, no interview with Christine, no zealous counsel, no hearing, no mental evaluation, and Christine found herself in a fraudulent guardianship. Fortunately, Christine could fight back. She reached out to SEER. We gave Christine the number of a trusted local attorney, and she commenced to gain legitimate counsel who would execute her expressed and best interest. Once Hemnes, Gao, Hackworth, and Whitney knew Christine was taking action to protect her freedoms, they took aggressive actions to isolate her. 24/7 overseers were placed in her home by August the 12th. Interestingly, Pierre never took our calls and never called or visited his mother, even though he lived next door. A case management Zoom hearing was requested on the afternoon of August 12th at 2 p.m., and the hearing held by Magistrate Weiss at 4:15, a 2.5-hour turnaround. In 4,000 cases, I have never seen a hearing requested and conducted with such speed, and certainly not with an incapacitated ward present. Christine, whose first language is French, was forced to participate in the hearing from her home while overseers held a smartphone in front of her. She claimed she didn't recognize a single person on the tiny 4-inch screen and was deemed totally incapacitated and unable to contract with the attorney she
10 seconds.
contacted. The attorney was also threatened with a bar complaint with false claims of solicitation. These type cases are what the public expects your task force to address. They are routine across Florida every week. We have the case data. SEER has proffered solutions to stop this madness. We continue to pray that this honorable task force is committed to reforms that will protect victims like Christine and her loved ones. Thank you.
Thank you, Mr. Black. Next, we have Susan Melende, and then we have a person, and you need to give your last name if you wish to be recognized. Michael, if you want to be
I
recognized.
believe that's our task force member, Ken.
Okay, we're going to skip him then because public comments for the public. Susan Melende, you're recognized, then Doug Franks.
Thank you, there's someone on the phone who wants to be recognized, Dr. Kennedy. Thank you.
Whoever's the person on the phone, you need to give us your name and you'll be recognized after Doug Franks, okay? Go ahead.
Thank
Susan.
you, Dr. Franks.
Thank you, Ken, and thank you to the task force and the discussions that we've had today. I advocate for an affidavit that would be provided to an individual before any proceedings can begin. We've seen that type of situation in other states. I also suggest that there be an alternative to probate court capacity and guardianship within a guardian ad litem type of model. I would recommend that the issue is not a probate issue and should be referred to the public defender's office so there is no conflict of interest. These monies cannot continue to come from a hardworking family, a firefighter, a nurse that worked their whole life. And as everybody has CMC hearings and regular hearings and ETGs and guardians, and there's no foundation to throw out the advanced directives, All of this money is spent and wasted from the ward. And Florida statute says it's all about what's in the ward's best interest. But we can change these statutes and laws, but if we don't follow them and pay attention to those basic premises, where are we? I am working on an affidavit and language for that. I've attached it to the task force for review, but I'll read some of the high points. The guardian ad litem or advocate for potential alleged incapacitated person. The goal is to offer the individual, family, and the court an option before any proceedings begin. The advocate would meet with the individual and review and assess the situation. We would contact next of kin and gather documents, including DPOA, healthcare surrogate, will, trusts, and all advance directives. If they have a family member that takes care of them, and we advocate for their rights and their advance directives. If they don't have proper documents, we work with them to get the documents that will assist them. We make sure if the person needs ADA accommodations or language assistance that we've talked about today, we would do that before any other proceedings. They would decide if they would like their information to be public or private, and if any proceedings would remain open versus closed. Again, Florida statute says that that's the ward's decision, not the ETG, not the guardian, not the court-appointed attorney, and not the judge. But we ignore that every single day. We would explain the statute that would have the right for their own counsel and the right to substitute if the court gives them an attorney. But again, that's Florida statute. I'm a perfect example. We didn't follow that statute either. We discuss with the person and their family if they need any supportive care plan in place in order to have their rights maintained and their freedoms to be
30
respected.
seconds.
The goal would be to put the ADLs and the financial support in place to respect the advance directives and DPOA and HCS in place. They would put their goals in writing and sign and date the affidavit, and we would have it notarized. In the event the court were to ensue with a case, the guardian ad litem would attend every single conference with the individual and advocate for them. We continue to outline best practices as it relates to the process. Thank you very much.
Thank you, Ms. Melinda. We appreciate your attendance at these and your comments.
Thank you, Ken.
Doug Franks, you're now recognized. And then the person on the phone, would you please give me your name so I can recognize you next?
Dr. Teresa Kennedy.
Thank you, Dr. Kennedy. And you're recognized after Mr. Franks. Go ahead, Mr. Franks. Mr. Franks, I think you're still on mute. So if you would unmute your computer there, that'd be good.
Well, yes. Okay. First of all, I'd like to tell you all that you needed to really listen to Sam Sugar and Rick Black, the guys that are they're experts. I would like to have an email of all the different members of this committee, if I can have that sent to me, or if it can be published. I was also an out-of-state guardian for my mother. I'm in Georgia. She was in Pensacola. And so I'd like to offer my assistance for a family member that was a guardian to this committee. Why is there not universal fees for guardians in the state of Florida? I mean, my guardian charged $285 an hour, and the first one only charged $85 an hour. It's crazy. There should be a matrix or a spreadsheet that shows the wards, the guardians in the state of Florida, where they're located, what they charge per hour, and how many wards they may have, and again with some additional things that may be important. The scenario of somebody that's say 17 years old and their mom or dad get put into guardianship. When they turn 18 and they can legally be the guardian for a for-profit guardian has their mom or dad or brother or sister, what is the chances of that person getting to be a family member and being the guardian when they reach legal age? And I'll tell you, that's a zero. It ain't gonna happen because there's too much money. There's a big thing about trust. All of us victims, we don't trust the system. It's shown up in my mom's case, and this is amusing. In her case number 2012 GA 00026, Judge Shackelford was the presiding judge for about 2 years. You won't find her name on the ledger. She never existed. Not on the judges. The judge that does exist never stepped foot in the Escambia County courthouse. What are we supposed to expect when we see that? What laws can be changed? How can things be done that we would ever believe that anyone's being honest? The judges, I'm sorry, and the attorneys, they need to have criminal charges. I don't understand why they can do things that are criminal and they get away with it. And they are criminal. And again, I don't like the word bad players. That's just, you don't call a rapist a bad player. They're a criminal. There's video that I took of my mom, and I think that should be part of
30 seconds.
things, that people are able to take videos of their loved ones and turn them into the court, and the court must view these videos. My mom definitely shows that she has capacity, and there is no such thing as partial capacity. It's either total capacity or total capacity. So those are a few things I wanted to run over. Don't think there's much more to say, but again, I'd definitely like to be more involved and offer what I did to help my mom recover and live a better, happier life for 45 days. Again, but you know, a lot of us, most of us, we love our moms, and I really love our dads. And being isolated is a human. It's a crime against humanity. So thank you very much.
Thank you, Mr. Franks. Thanks for being with us today. Dr. Kennedy, you're now recognized.
Yes, thank you. I'm Dr. Teresa Caba Kennedy, founder of Elder Dignity, a national advocacy initiative. My aunt, Dr. Lily Sykes White, was victimized under a fraudulent guardianship in Florida for 8 years. She died on December 30th, 2020, apparently of COVID-19. They cremated her immediately, and we didn't find out she died until almost 2 weeks later. There's a lot I could say, but today I have 3 questions for the committee. First, it has to do with preventing isolation. How do we make it harder for a guardian, or in our case, an improperly appointed emergency temporary guardian, to seize and isolate a senior? Isolation enables exploitation. In my aunt's case, there was never any substantiation of emergency or danger. In fact, we have 2 police reports indicating she was safe in her home, and 2 doctors' statements saying it was a good care situation, and it was her written wish to be in her home. It didn't matter. My aunt was seized, harbored, and exploited. That meets the 3 constituent elements of human trafficking. But no one in Florida really cares. Who in Florida addresses that? So the second point or question has to do with speed of intervention. Who in Florida can be granted the power to intervene quickly to save a senior's life when there is forced isolation and many irregularities? I'm being kind in saying that, in terms of court oversight. This has to do with my aunt was isolated for 4.5 years from her chosen family with no substantial justification. No one in Florida did anything. And it seemed like no one had the power or the will to save my aunt, even the governor. They just let her die. The third question has to do with the license to lie. How do we minimize the license to lie by guardians and attorneys and untangle fraud on the court? We now have an investigation report on the Guardian from the clerk, Anthony Palmieri's group, and OPPG, that shows the Guardian violated multiple Florida statutes, some which rise to the level of criminal violations. But who prosecutes that, and who untangles the fraud? In talking with investigators and some of the people on this committee, there seems to be an acceptance that attorneys and guardians can lie. But this is a person's life, and the false representations in our case led to my aunt's death and also unwarranted sanctions on my 85-year-old mother. So even though Aunt Lily is dead, it continues. So at the center of the guardianship system should be the senior. How do we help the senior thrive while minimizing the financial impact on the senior's estate? It's my hope that the task force meditates on that one.
Thank you, Dr. Kennedy, and thank you for your participation today. I will ask any member of the public, and Sue Melendez has sent us some tangible things. If you have tangible items that we can put into Florida statute that you're recommending to improve the system, we certainly want to take a look at these things. We realize that there's issues with the system, and we certainly, that's the purpose of the task force, is to make legislative recommendations that can be put into statute, and our legislature consider to make the system better and to protect the vulnerable in the best way possible. So any suggestions you have, I know folks have shared their different issues and their the problems and legislative solutions certainly are welcome and recommendations. So we certainly welcome you to go to our website. It's easy to remember. It's the name of our taskforce.com, Guardianship Improvement Task Force.com. There's a place there where you can contact place where you can put your recommendations in there, and we are taking these seriously. It is now 2:02. We're 2 minutes past our time. I want to thank again our presenters today. I want to thank the members of the task force. Our next meeting is going to be on September 2nd. We may have to increase that meeting by like a half hour with all the presenters that we're going to have that day. So we're going to see if we can come up with a good schedule, but maybe folks, if you can look at your schedule, and I know this is asking a lot of y'all, but to see if we can go from 12 to 2:30 on that particular meeting. It's going to be a great meeting because Anthony Palmieri, our vice chair, is going to chair that meeting and lead you all on that one. And so, Anthony, I appreciate that. Also, I want to point September 16th will be our next virtual meeting after the next one. And then please, please, please put on your calendar September 23rd. That's our all-day meeting in Tallahassee. We're hoping to have it at a location. Well, we're going to have it at a location very close to the Capitol. So if our senator and representative can escape between committee meetings or after, they'll be able to join us. We're going to be at the Turnbull Center, by the way, Senator. I see you there, and Representative Burton. So hopefully we can we'll even come pick you up if needed to bring you over there to participate in the in-person. The in-person is really going to be set in the stage of deliberating what we want in the report. And Tom Hall's going to have a lot of the suggested items gleaned from our conversations put in the report, but then we'll be that's our deliberation time, a lot of deliberation time to figure out what we want in that report. So if there is no other business, folks, this meeting is now adjourned. Thank you all for your participation.
Thank you. That was a great meeting.
Yep, thank you.